Any mention?
But, not I beg to make a mention of item 7 of the hearing this morning.
Item 7.
Yes, ma'am.
Yes. Yes.
Not not ready with the matter today. In fact, I was out of station, my lord. I just reached this morning.
No objection. Service matter?
Yes, my lord.
Okay. On the request of the respondent, government advocate.
Yes, sir.
List this matter after 2 weeks. 2 weeks. Obliged.
But for that matter, I also wanted to mention another matter, my lord. Item 10. I had informed my friend.
Your Lordship, my seniors on his way, Your Lordship. Actually, let the matter come up, Your Lordship. He has some submission to
Yes, yes, let him come. Let him come. Let him come.
Okay.
Please, Your Lordship. Lordship, I beg to mention item 9, Your Lordship. I pray, Your Lordship, please matter to come after 3 weeks, Your Lordship.
Other side?
Yeah, MECL is the main party, my lord. State is a formal.
Who is appearing for MECL?
R. Kulni, she is in the other court. She had informed me also.
She has no objection.
Okay.
2 weeks.
3 weeks, Your Lordship.
On the request of the Learned Counsel of Petitioner, list after 3 weeks. Item 9. Item 9, isn't it?
Yes, Your Lordship.
It was it item 9.
Item 9, Your Lordship. Highly obliged.
Lordship, I beg to mention item number 11. Lordship, sir,
We are
our
appearing for the
rule-
respondents, state respondents.
Yes. I'm with British Lordship.
Yes.
Lordship, sir, our Gurung is unable to take up the matter due to some personal difficulty. So, if it may appear after the pujas.
No problem, Malad. But on the last occasion, in fact, the counsel of the respondent number 1, number 2, Your Lordship, he had not appeared. In fact, a junior counsel, and he is here today before the Honorable Court.
The private respondent is there in this matter.
Yes, Lordship. Yes, there.
They have not entered appearance in this.
No, Lordship. No, Lordship.
So we can
On the
record.
one occasions they had appeared, and they had prayed time, my Lord, for filing the wakalatnama.
Malad, till date we haven't received the wakalatnama from.
So how can you enter appearance? The same thing situation continues. Then we are not. See, if you do not have power, do not appear, please. Do not embarrass the court. This becomes very embarrassing. You see one's court process. But then next day you do not bother even to appear before the court. As a lawyer, it is your duty. If you are not engaged, also you just say inform the court. None appears. This is very bad. Okay, on the request of the Learned State Council, state respondents, list is met after 2 weeks. Item 11.
Highly obliged, Lordship.
Obligation.
Do not record appearance of private respondent. Not really.
May I please, Your Lordship? I beg to mention item number 12, Your Lordship. I pray for 3 weeks' time.
3 weeks.
What is the matter about, Mr. Khan?
POXO matter
POXO court transferring
to the Sessions Court.
Oh, acha. Because the
Age.
yes, victim was found to be major.
found to be above 18.
So why 3 weeks? Why unnecessary to keep it these things? We should. The matter will go away.
Court has granted stay, so
That is what. Not 3 weeks. 2 weeks. Not 3 weeks. 2 weeks. On the request of the Learned Counsel of the Petitioner. This is item number 12.
Mainers, item number 1.
May it please your Lordship.
Yes.
Lord, WPC criminal. Lord, the petitioner before Lordship, my Lord, he is a student. And I have annexed his identity card as page 70. 17, my Lord.
Yes. What is the matter about?
My Lord, the impugn FIR, my Lordship, will find at page 19. Page 18, my Lord. FIR.
Mr. Paske is also there in this matter.
My lordship.
He's appearing for.
Petitioner, my lord.
Oh, he's appearing.
Yes, Your Lordship.
Yes, my lord. So page 18 is the FIR, my lord. May I read, my lord?
Oh, Ajay, that is that matter.
Yes, my lordship. And page 19, my lord.
Mr. Shula, there is another matter. I
Lordship,
think.
yes, it's coming on. It's one is coming on 19. One is coming on.
Another fresh matter we have called for case diary.
We'll have the case diary in the. That is WPC number 4 of 23, Your Lordship.
When
That
it is
will
coming
come on 19. It will come on 19.
Take it up on 90 because we'll call for this case diary. We'll just see the involvement.
The rule.
Why after so many days? If you are not arrested, why? What is the apprehension?
My lord, because similarly situated some two more
That is, you have
accused
given
there.
at that point of time.
My lord.
But then you have come after a long gap.
My lord. Because
You
he's
see-
a student, my lord, and apprehension is always there, my lord. So, my lord.
Nothing has happened till now. Where is the question of having any apprehension?
Your Lordship, more so because he's going to get married recently. ma'am.
36, his family has.
See, he wants to have a secured ceremony.
Yes, Your Lordship.
Mr. Shula, if you take instruction whether the custody will be needed or not, I mean,
Lordship, let it
just
come
that
on
will be
19.
seen.
We'll,
If you have not
inform-
arrested somebody,
we'll inform this court accordingly, Your Lordship.
if you not arrested somebody for so
We'll
long,
inform-
so
we'll
why
inform
to
on
keep them
19th.
under fear?
My lord.
It will come up on 19th. 19th is it?
19, yes.
You just say, Mr. Andy Shulai, learned the AG will produce the case diary. List this matter on 19th. We'll take up.
My lord.
Deeply obliged.
Item number 2.
Yes, what is this?
This is an application, criminal revision, my lord. Challenging.
There's a delay.
My lord, there is a delay of 45 days, my lord, preparing this revision application.
Office note says 51 days. You have seen the office note, you have not seen.
No, my lord, I have not seen.
No one is appearing for that. Who is the other side?
The state is the other side, my lord.
Yes. No one is.
Legal aid matter, my lord. I think so.
Are you appearing here? You are not sure.
I'm not sure, my lord, but I am entering appearance.
Yes, what do you say? What is your submission?
If my friend gives me a copy of the petition, my lord.
Acha, you have not supplied them copy of
We
the
have supplied, my
petition.
lord. We have
You are
taken.
appearing with what, Mr. If you are not prepared, just you. See, just it should not be something like that. You just stand up and ask for a copy of the petition which has been supplied to you long. You do not know even that also.
My lord, my apologies.
No, no. What kind of thing is this? Just there is a limit to things. See.
My lord, this I am not sure it is endorsed to.
First of all, you do not know whether it is your case or not. Then thereafter, you take time to ascertain it. Once you ascertain, then you say you do not have a copy.
My apologies, my lord. So it is taken
This is
up
not-
next date, my lord. It is kindly taken up next date.
I'll supply a copy to him.
I'll find out also, my lord.
I have already supplied to the state, my lord. So since he is appearing, my lord.
This is something. See, normally, if a matter is filed,
My lord.
I think I was there on that side
My lord.
for quite a long time. So it is endorsed.
My lord.
So what is endorsed, you verify your matter. It should not be something like that. You stand up here and you say, I do not have a file, and I do not know.
My lord. My apologies, I'll get it verified. I'll enter.
When?
After puja,
After
my lord.
vacation.
On the prayer of the Learned Council for the parties, list this matter after 2 weeks.
My lord.
Nice.
Item number 4.
Please, Your Worship.
Yes.
Already taken steps as per the status from the whose office. They've been delivered.
But then you have
That
to
is
file
to
the
respondent number 2. I'll file my service.
You filed your service.
I am for 1 and 6. Please tell.
Yes. Office note dated 13/10/2023 indicates that ID card and respondent number 2, 3, 4, 5 and 7 has not yet been received. Stop. Nana Council for the petitioner submits that he would verify the status of service with regard to the said respondents and will file an affidavit of service.
1 week.
Stop. List this matter after a week.
Pleasure.
Item number 5.
It please your Lordship.
Yes.
On the last occasion, we had argued extensively on the provision.
What's the matter about, Mr. Quinta?
This is a matter where I say a teacher who's disciplining a student will not be punished or for an offence under the JJ Act. Now, I'm here before this court. This court wanted whether I have got some precedents. We have done extensive research, and one particular precedent is of the Kerala High Court.
Yes.
And this is a judgment which has extensively gone into the provision of the JJ Act, and the case is very similar to my case.
Yes, Lordship. What's the relevant part?
I thought I will, Lordship, if the court permits.
Yes.
I'll start right from the first part of the order, without because otherwise, without a conjoined reading.
So that means we have to go through the entire.
I have to.
Not that paragraph 11 which you have highlighted.
I have highlighted paragraph 11. Then in that case, to save the time of the court, the above act of
it's
the.
Okay. It's all right. If you want that to go to the entire
I
judgment
thought it
for
will be
proper
nice.
application, we can do that.
Lordship. It will be very educative for
There is,
all of us.
there is no shortage of time for this court.
My lord, before my senior begins, my lord, this is the matter where I had sought for adjournment.
The problem here, Your Lordship, is that I was traveling purposely for this particular one case. I rushed. I spent a lot of money to come here. He could have informed me one day ahead.
I was also out
This
of
is
station,
always a practice by the government council. In some
my
other
lord. If
cases
that is
also,
the
I'm.
case, my lord, next date we'll finish it.
That's
My lord
not
will
a-
fix any date.
Now the accused, who is
My
a
lord,
teacher,
as I was out
not
of
only a
station,
teacher.
I had made a request before this honorable
Even
court. I
see,
reached
when
this
you
morning,
have
my lord.
when you have senior counsel appear for the other side, it becomes a courtesy.
No, my lord, before he came, I
You should
informed
always-
him.
You should see, this is what bar has its own culture,
My lord,
and you keep that culture.
then I'll maintain it, my lord. The
Just
thing is that I had informed his
This is
junior, my
something-
lord, before he came.
That's not enough. Just before the matter is taken up,
You
you are
don't get him, you
informed.
can inform any of his juniors.
At least beforehand,
I'll
he
do
could
that,
have.
my lord, next time.
He may have some other matters to appear.
I was traveling, in fact, Lordship, rushed last night, just to be here for this case, because I have huge respect for the majesty of this court.
Anxious to hear you because it's quite interesting matter.
Very interesting matter. Then I have noticed one thing.
No, by the way, one thing, Mr. Quinta, you are holding Juvenile Justice Act. Are
Yes,
you? Are you? Are you?
Yes, yes.
See section. This is concerning section 70.
75.
You have been 75.
Yes.
See section 74, which prescribes punishment for publication of news divulging details of a victim, probably, if I am not mistaken.
Yes.
Now, may not be just we are maybe having just widening the discussion perhaps. Now there you will find a provision says that whoever makes any sort of disclosure publicly with regard to a
Which section is that, Your Lordship?
74 probably.
Oh, acha, disclosure of identity of children.
Yes. Now, say supposing victim, ordinary victim who resides with the parents and all, meets with some sort of unfortunate incident, and that is made public by somebody. Now that public is by somebody, that person is sought to be charged under section 74. Now can we again raise the same plea which you are saying here?
Lordship, I have to, because I'm here not only to serve the cause of my client, I'm here to serve the cause of justice also. And the rule of law, what does it say? I have gone through this particular law. I have noticed one thing, Your Lordship, that suppose I employ a child who is minor, I'll be punishable, Your Lordship.
No, that is when the child is under your custody. But then I'm not saying that. My thing is that only with regard to the passing of the information, nothing else. I'm not saying, I'm not talking about the person who is accused of commission of the crime. Kindly appreciate. You see, because this 74 prescribes punishment for divulging the details of the victim. Okay. So it doesn't, see, it is not required that that person has to be directly involved with these things. Something happens somewhere, I come across it, I call up press and media, and I say, see, this thing happens with that person.
Oh, there's an abetment.
Okay.
There's a clear case of abetment where there's a clear case of a bar for disclosure of the name of victim, etc., etc., etc.
So, but then in such a case, if a person is supposed to be charged, if I am charged under section 74, can the same plea be raised by which you are raising now, saying that the child is not a subject of the Juvenile Justice Act?
No, my case is completely a different case altogether, where I say that I'm a teacher.
Yes.
I disciplined. See, I inflicted some corporeal punishment. Whether I escape the clutches of the law, where I should not be punished or something like that.
See, your submission was something like that. This Juvenile Justice Act will not apply.
So far, my case is concerned, where I'm a teacher, I inflicted some punishment on the child, disciplining. I have the exceptions under the Indian Penal Code, section 79, 88, 89 onwards. This judgment has gone into the entire exceptions provided for a teacher. And it also very clearly says that inflicting of corporal punishment, some amount, not very serious, I'm not saying a very serious, minor, something slapping or something like that, will not fall under the four corners of this law.
Anyway, that whether it was a minor slap or not, that's all will become subject matter of evidence. Now, your plea in this case is that you cannot be even charged under this.
Yes.
So, we are not going to that part, you see.
My area of submission is limited
is
to...
That you just say that prosecution basically cannot charge me under 75.
Yes.
Because this is a thing, but I will be immune of that thing.
Yes.
That is what you want to say.
The definitions.
So that is what, that is why this 74, the court has cited this example of 74 and put to you that question.
I hear 74 is...
will be available for a person who makes this news public.
He will be liable for punishment under this law. Because there is a clear...
He cannot raise that same argument.
No, he cannot. He cannot. The law is very clear that in the event of disclosure of the name of the victim, school, etc., etc., he is a punishable offence.
But that victim, if it is not a subject of, doesn't come under the definition of section 2 which you have read out the other day, then what happens? Here your case is also same.
The
victim is...
In so far, because I have gone further into the law also, it speaks about I have used a child for a purpose of robbery or dacoity or something like that, then it is here in the section.
We are not going into all those things. Please try to understand. We do not have to refer to facts and all those things. Okay. Your case, the incident is that teacher slaps a kid. Kid goes, files a complaint, and you are booked under Section 75 JJ Act. You come to NCIC. This victim is not a subject of the JJ Act, cannot fall under the category of a child, which is defined these things. So I cannot be charged under JJ Act.
Some other laws are there under the Indian Penal Code for offences against any human being, be it a child or...
But then, see, you say that we cannot come under JJ.
Yes, that's a clear-cut
You are not saying that you are not liable to be prosecuted under law. There may be different law under which you may be.
We are not coming into that. I am saying that a teacher is not punishable under this particular law. That's my submission. Because a child, as insofar as student is concerned...
Your exemption is solely on the basis that the person concerned is a teacher.
Headmaster, she's a headmistress.
So, it will not apply to a general person.
It will not apply to. That's my...
So, the application of section...
Now
give me a juvenile justice.
We have to read clause 13, 14 and 24 of the section 2 definition clause. It will become crystal clear that a headmistress of a school cannot be prosecuted for...
No, see, we can understand. See, like perhaps this court is not able to communicate you communicate to you what court's query is. Now, referring to section 1, subclause 4, your submission was that the provision of this act shall apply to all matters concerning children in need of care and protection and children in conflict with law.
Exactly.
Now, these are defined again in section 13 and
14, clause 13 and 14.
Yes. Now, this is what? Probably, perhaps this court has understood that much of your submission. Now, the same will apply if this same sort of, you see, same thing applies to section 75, it will apply to section 74 also. Now, that is the court's query is that when a person is charged under section 74, can he raise the same plea?
Interesting. Interesting.
I do not know, person, is he, could you get the query of the court?
If you look at section 83, section 83, because I'm here not only to serve my cause, I've submitted.
You have said, and that is what is expected of a senior counsel.
I am here to.
See, that is what is expected of a senior counsel.
When we look at section 83,
yes,
use of child by militant groups or other adults.
Yes.
Any non-state self-styled militant group or outfit declared by the central government, if recruits or uses any child for any purpose, shall be liable for rigorous imprisonment for a term which may extend to 7 years and shall also be liable to fine, etc. Now, when we look at section 84 also, this is kidnapping and abduction of child.
So these two provisions, is it not that it goes against your argument?
In so far these types of offences by adults is concerned, perhaps this law has been thing.
So
I'm talking about a teacher and a student in a school.
So that the court will have to classify. Court will have to classify, make a distinction with it.
Your Lordship. That's what I'm trying to say in the earlier thing also, that so far a student in a school, disciplined by a teacher, whether he escaped or not, that's the point. Whether he falls under the...
If a teacher commits brutality, even in that case also...
General law.
General law.
Yes.
Cannot come under.
Yes, yes. There are so many decisions of many high courts on this matter. But the one which is very, very relevant is the one I have... brought in before the court today.
Yes. So, shall we proceed, but then
I don't know, Your Lordship, because I'm not here also to just press my case when the government counsel says that he's not ready. And I'm also at my stress level is very high, being a headmistress. I run the school, and my reputation also is at stake because of this case. It is hanging over my head. I wanted to clear this matter at the earliest. That's why I have come before this court. I don't want to face trial and subjected to so many things. We tried to explain to the lower court, but they refused to accept. They went on a different line altogether. That's why I'm before this court. And if the counsel for the government desire another date, perhaps I'll have to say no objection, Your Lordship, at this stage.
Next date we'll finish it, my lord. Only difficulty, my lord, even I was not in station. I reached, my lord, immediately.
See, Mr. Kepi, you are appearing cases. This court basically it knows the strategy which you apply in your cases. And these are the cases not to be taken lightly.
My lord.
You have to find out, sir. See, the learned senior counsel's argument would go to many things, because the court also will put some queries, you see.
My lord.
If it did not come, sorry. If you do not come prepared in this kind of matters, well, it's difficult.
That is exactly why I prayed for adjournment, my lord.
This was the third occasion that we argued. Last occasion, the court was kind to allow the government. It's not that it was, the case came up by several posted several times.
This is an interesting question. You see, like generally also, once you come across this kind of things, you would try to find out, try to achieve some conclusive view.
We try to search for Supreme Court decisions. No.
This one, which part will be? Or shall we go today, or shall we adjourn it simply?
We'll adjourn it because since they are already feigning without briefing.
Shall we give back your thing to you?
No, it's court's copy, Your Lordship.
So we'll keep it in the file.
Yes, Your Lordship. I've given them a copy also.
Yes. I'll also examine it, my lord.
Please, it will be so kind of you if you do that. When do you?
Tomorrow.
Tomorrow.
Tomorrow is difficult, my lord. Let it come after the vacation, my lord. Any date.
Okay, we'll have it after 2 weeks.
My lord.
On the request of the Learned State Council. This matter after 2 weeks. Here's something, and please, if you don't want to do, if you have any problem, inform the Sanjay.
One day ahead, at least we'll know. We'll plan accordingly.
One day ahead, they also do not know what they.
No, but they know.
My lord,
because just before reaching the court, they informed, and just imagine, Your Lordship, what my client will say. I've informed my client that she's online, she's watching from YouTube. What will my client say? That today's matter taken up and adjourned, I'm not there. That's a we face problem.
My lord, there will be no adjournment from my side.
With this online thing, it has become a big problem for lawyers. They have to
It is not online also. You see, it should not, there should not be something should not be done unnecessarily. See, once you are engaged, you do your professional duty.